Okay, good morning. Can everyone hear me?
Yes,
Welcome
sir.
to, welcome to an oral argument session of the Fifth District Court of Appeal here by Zoom. Please turn off any electronics you may have that may interrupt your counsel or the panel during the session here. I'm Judge Eisnagel. I'm presiding today. I'm joined on the panel by Judge Wallace and Judge Boatwright. We have two cases on the docket today. Our first one is 240064 Longman versus Story Mountain et al. Correct? All right. Very good. Well, counsel for appellant, if you'll let me know how much time you would like to reserve for rebuttal, I'll attempt to help you keep track of that. Ultimately, it's your responsibility, but I'll try to help out and let you know when you get there. Of course, it's your prerogative if you keep going or not. But I'll try to help you keep a look on the clock. So, counsel for appellant, if you'll let me know how much time you'd like to reserve for rebuttal, and then we'll be ready to go.
Very good. Good morning, Your Honor. I would like to reserve 5 minutes for rebuttal, please.
All right, counsel, whenever you're ready, please proceed.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. My name is Vincent Sullivan, representing appellant Stuart Longman. We have here before Your Honors today what appears to be a novel issue out of the appellate courts here in the state of Florida. We're asking this court to determine two things. Number one, where does the situs of money deposited in a bank account reside for jurisdictional purposes in the context of a writ of garnishment? The second thing that we may defer deciding on based on how the Florida Supreme Court determines in its Lumpos case is what is required to create the unities that are necessary to create a joint tenancy by the entireties. Obviously, Mr. Longman feels that the underlying trial court incorrectly granted a judgment in execution of writ of garnishment for the foregoing reasons. So probably the meatier argument I'd like to start with today is the jurisdictional analysis. The garnishment statutes are in derogation of common law to the extent that common law didn't recognize writs of garnishment. So with that backdrop being painted, the courts have uniformly stated that because they're in derogation of the common law, they must be strictly applied and strictly construed. The timing is mandatory, the filing of responses is mandatory, and the penalties are severe for not complying with the strict mandates of the statute. For example, if you fail to answer, it is in a default posture. No motions are necessary, no delayed filings are permitted. So just to kind of give the court a backdrop on the severity and the sincerity with which the timing is important. And we focus on the jurisdictional nature primarily because garnishment proceedings are said to be quasi in rem, meaning that the court must have jurisdiction over the person and the thing to be garnished. There is no question in this case that the garnishee, KeyBank, was subject to the personal jurisdiction. That's
Mr.
never been.
Mr. Sullivan, did KeyBank, when they answered, did they ever challenge the jurisdiction over the funds?
No, Your Honor. The answer filed by the garnishee, KeyBank, in this matter never challenged personal
The
jurisdiction.
Vanguard did, correct?
Correct, Your Honor. Vanguard did.
So can appellant raise that issue for KeyBank?
Your Honor, appellant's not raising the issue of personal jurisdiction. Appellant's raising the jurisdictional issue of in rem jurisdiction over the funds that were being held by KeyBank. And I think that's a key distinction, right? Because personal jurisdiction is unique to the person. And the case cited by Story Mountain, the Merriam-Webster case, I think is.
But does KeyBank challenge any type of jurisdiction over the property or over their person?
No, Your Honor, it does not. The garnishee does not challenge any form of jurisdiction of the court. But I believe Mr.
Does
Longman.
the appellant have the ability to then challenge that jurisdiction if KeyBank never did?
I believe it does, Your Honor, because KeyBank is a custodian of funds that are owned by Stuart Longman. Mr. Longman and the tenants by the entirety's unity that we're going to talk about shortly, that's the owner of the funds. So KeyBank is in constructive possession. They're essentially a fiduciary for Mr. Longman and his wife. So I believe it is definitely vested in Mr. Longman the standing to say, hey, listen, while KeyBank is holding these funds, I've got the right to assert my marital protections of these funds. So, and that's really where the crux of this argument gets, because if we look to the federal district courts, whether it's Middle District or Southern District or the Northern District for the federal courts here in Florida, they appear to have taken the position that, listen, Because of the e-commerce world we live in, I can deposit money in my bank account here in Flagler County, Florida, and then go to Savannah, Georgia for the weekend with my family and pull that money out of the bank account in Savannah, Georgia. So it becomes difficult for jurisdictional analysis to determine where is the situs of the asset to be garnished, right? That's the question we're asking this court.
Who has the burden on that issue, counsel?
Well, ultimately, the burden rests with the movement of the garnishment. So in this case, it'd be Story Mountain to prove that the court has jurisdiction.
To establish subject matter jurisdiction.
Correct, Your Honor, to establish subject matter jurisdiction.
You know, it's interesting, these cases, certainly there's a lot of opinions out there that categorize this as quasi in rem. But it's hard to find any sort of analysis as to why that's the case. It's a lot, there's a lot of conclusory sort of statements. I did go back and see if I could find the basis for it. But I'm not gonna poison the well here. I wondered if you did, and why? Why is this quasi in rem?
Well, Your Honor, I believe it's quasi in rem because you're not asking for jurisdiction over the individual. You're asking for jurisdiction over the item, right? So here we're talking about cash, whether it's in digital form in a bank account.
Well, why isn't it like shim, right? Once you have personal jurisdiction, and by the way, this is sort of a devil's advocate argument. I'm not saying that it is like shim. I'm just saying, why isn't it? Once you get personal jurisdiction over the garnishee, right? The garnishment proceeding is perhaps a separate proceeding, right? Once you have personal jurisdiction over the garnishee, why does the trial court not have authority to tell the garnishee over which it has personal jurisdiction to turn something over, just like in shim?
Well, and as Your Honor is well aware, having authored the 5th DCA opinion in Bushell versus Shim that was ultimately approved by the Florida Supreme Court, that dealt with proceeding supplementary under Chapter 56. So those are two separate chapters that we're talking about in the Florida statutes. 56 concerning—
Sure, but why? Yes, but why are they different?
Well, they're different because if you look at Chapter 56, subsection, I believe it's 29, or excuse me, 5629 subsection 6. That is where I believe Your Honor can base the authority to compel a defendant. And I want to emphasize the word defendant because that's what the Florida Supreme Court emphasized in its ruling. It can compel a defendant over whom it has jurisdiction.
Mhm.
So if we look at 5926 under proceeding supplementary, it specifically states that the court can act upon property owned by the defendant or in the possession of any other party. The statute's explicit in saying that the court has jurisdiction to force somebody else holding that item.
And it wouldn't just, I mean, I don't think there's any magic words. I mean, magic to the fact that it's a defendant versus a garnishee, just the word itself, but maybe there's a substantive difference. What is the difference?
The substantive difference that I've been able to discern is that there is no similar language in Chapter 77 permitting the court that jurisdiction, right? There's no language in 77 that I'm aware of that says, hey, I can compel you to act on out-of-state items, right? Because what we're doing—
Is there express language in 56 saying the court can compel action on out-of-state? I don't recall that. So since I wrote shim, so it may be there, but I just don't recall it.
Yes, Your Honor. So in 56 itself, no, it does not speak to extraterritorial application, but that's the distinguishment over the in rem jurisdiction, right? So in shim, it says, and I think it can be reasonably extended in proceeding supplementary to a third party holding that asset, it can coerce whomever it has personal jurisdiction over to bring the asset within the jurisdiction of the court. So then the court can act upon title to the property.
Does it matter? Does it matter that a garnishee is not the owner of the asset? They're just sort of they're just holding it. Whereas a defendant theoretically is the owner.
So I believe that is just the difference, Your Honor, is that, again, the bank here in this case, Key Bank, is just a custodian for funds that are owned by Mr. Longman and his wife, right? They're the holder. So their Key Bank branches all over the Eastern Seaboard. Mr. Longman can deposit it at his home state and pull it out from another state. That's the beauty of the modern commerce world that we live in. So that is 100% the distinction. Is what the underlying court here did is it compelled a third-party non-party who is simply a fiduciary in constructive possession of the items not owned by them and acted upon not only title, but went beyond the statutory authority that they had to direct that this garnishee bring funds within the state. Specifically,
I don't think the initial brief cites to the Burkhart case. It's a very old Florida Supreme Court case that it's one of the first cases that I was able to find that indicates this is a quasi in rem issue. And there's not a ton of analysis necessarily in it, but it does indicate that it seems to indicate that, look, when you're dealing with a writ of garnishment, the court is actually seizing the property. And perhaps in this shim situation, the court isn't seizing it. The court is telling the owner, "Hey, I have personal jurisdiction over you. You have to bring this property here." Perhaps that's a difference between 56 and the writ of garnishment seizing versus not. Just curious again, and I've probably maybe caught you off guard because you didn't cite Burkhart in the initial brief, but and I have another one for you that you didn't cite in a minute. So just you have that. That's exciting, right? That one's coming. But I'm just curious. Look, I care about obviously the panel is going to care about whether the law, as conclusory stated in a bunch of opinions, is correct. And so I'm trying to understand why the conclusory statements in so many, in a handful of opinions, not so many, right? I mean, a dozen. Why is that correct?
I believe it's correct because if we were to say that the state of the law here in Florida is that we can direct somebody who's got no contacts with the forum state, right? We'd essentially be throwing the Venetian salami test out the window. So if I can go to a local community bank out of state and say, even though your customer lives in the state of Florida and you've got no contacts other than your customer in the state of Florida, we're going to tell you, Community Bank of Ohio, that you're going to do what the Florida court tells them, right? But
once there's personal jurisdiction, why is that an issue?
Well, Your Honor, I think that becomes an issue of that is the issue rather, right? It's personal jurisdiction. There's no argument that Key Bank is subject to personal jurisdiction, but it's the jurisdiction, I think, over the asset. That's really where the distinction is you can't tell an asset that's located outside of the state, you can't act on property.
We could do this exact same thing if the garnishee were a defendant under shim and the proceeding was under shim. This exact same thing could happen. In fact, like this, I mean, if this was not a garnishment proceeding, if this was under 56, would we be here?
Your Honor, respectfully, we wouldn't be here because of 5629 sub 6.
So I'm just trying to find out what you think the substantive difference is. I understand in both situations, there's personal jurisdiction, right?
Correct.
In both situations, the property is out of state and the trial court has no jurisdiction over the property, correct?
Correct.
Okay. So what's the difference then? Why is it okay in shim, but not okay here?
It's okay in shim because of 5629 sub 6. It's not okay in this case because there's no similar statute under 77.
Okay.
And what you're doing under 5629 sub 6 is you're acting or you're directing the individual holding the asset to bring it in, right? So
versus the owner. Is that the key versus so the trial court's not seizing it in under 56, but it is perhaps is seizing it under 77. Okay, before we run out of time, I need to ask you about this too. Again, I don't think this case is cited in your initial brief, and I'll just tell you, I just did a word search and it doesn't come up. We have a case that's relatively new called Navy Federal versus Nicholas Financial that seems to be dispositive on this issue. It seems to be binding on us. Have you read that case?
I have not had the opportunity to, Your Honor.
Okay, all right. It seems to support your position, but perhaps in your rebuttal, if you find it in your notes, I'd be interested to hear what you think. But it's Navy Federal, and I'm sorry, I should have the citation, but I didn't write it down.
Navy Federal versus who, Your Honor?
Nicholas Financial.
Yes, Your Honor. I will double duty.
The citation's 411 Southern 3rd 494.
Thank you, Your Honor. Definitely take a look at that and be ready to speak about it in my rebuttal. But I think looking at the clock, I think we fairly will cover the jurisdictional portion that I've got time for today. I want to briefly touch on the joint tenancies by the entireties. Obviously, the Supreme Court is working on determining whether or not the amendment to the statute 65579 requires the unities. So I'm going to ignore that because I believe the Florida Supreme Court in their Lumpos oral argument that was held in June is going to determine that.
If we determine the trial court had no subject matter jurisdiction, we don't need to decide that anyway, right?
Correct, Your Honor. I think if this court and this panel determines that there was no jurisdiction, that ends the inquiry, right? I think, however, if this court determines that there is jurisdiction, then I think we have to get to 65579 to determine whether or not the unities are required, right? Because if we look back at the evidentiary hearing transcript, there is unrebutted testimony that the bank account lacks the unity of time and title, plain and simple. So I believe that is fatally deficient to this claim. However, at the time that the evidentiary hearing occurred, the only appellate court decision to talk about the 2011 amendment to 65579 was Versace. And it essentially said, we don't look to any of the unities, right? So that's where the root of this problem comes from, is even if we ignore the jurisdictional analysis, the only appellate court decision on this matter said unities don't matter. Any account owned by a spouse, any account or deposit made in the name of two individuals that are married shall be the compulsory shall be determined husband and wife. So again, I don't want to spend a bunch of time on that because I believe the Florida Supreme Court's going to take that up for us. But the next argument, though, that was really focused on, especially in the trial court's opinion,
Counsel, you're in your rebuttal time. You can proceed as you'd like, just letting you know.
Very good, Your Honor. I think I'll go ahead and save those for my rebuttal.
Okay. All right, thank you, counsel. All right, counsel for the appellee, whenever you're ready, you can proceed.
Good morning, Your Honor. Paul Humbert, may it please the court. Represent the appellee Story Mountain. I want to address, Your Honor, raised the Navy Federal Credit Union versus Nicholas Financial. And I'm just reading this opinion, wasn't aware of it, but looking at it, and I can distinguish it for the court because obviously it's at first glance when I first started reading it, I'm saying, oh no, this could, this could be a problem. But I think if Your Honor looks at the last paragraph of that opinion, and the opinion appears to have been drafted by Judge Wallace, and it was fairly recent, so there probably some familiarity with what transpired there. It actually supports Story Mountain's position here entirely, because the garnishee in that case, and I'm going to quote from the end of the opinion. It's at page, well, it's on the fourth page. It's on the third to fourth page of the opinion that, as you all would have it. I don't know whether with the reporter on what a page it would be, but it says, here, appellee claimed in its motion for garnishment that the lower court had jurisdiction over appellant. However, appellant asserted in its amended answer that the lower court lacked the subject matter jurisdiction over the case because the property was not at issue, was not located in Florida. In this particular case, I believe, Judge Boatwright, you raised it at the beginning of Mr. Sullivan's argument. KeyBank the answer to the KeyBank garnishment did not contest subject matter jurisdiction. So what you guys were doing here in the 5th District in Navy Federal Credit Union was all that this case is saying is that we're going to take the pleadings as framed. What are the pleadings in a garnishment? It's the writ of garnishment itself, and it's the answer of the garnishee. Those are the pleadings as framed. The evidentiary hearing that gave rise to this appeal is the equivalent of the trial on the facts. But if this was all framed in the context in the Navy Federal Credit Union of a garnishee, of the answer saying you lack subject matter jurisdiction, we go through this in painstaking detail in the answer brief. Mr. Longman never, ever addresses in a pleading or otherwise, in the pleading would have been there's the garnishment, the answer to the garnishment, and then if the creditor is not happy with the answer, the creditor could file a traverse. I was fine with KeyBank's answer, so there was those issues, there was never a dispute as to jurisdiction. Take a look at the record on the direct examination of Mr. Longman at the hearing. There was an evidentiary hearing on this issue. There's not a word of where do you live, where was the account open, and we go through this in the answer brief. So I'm not going to belabor the point.
But counsel, look, I appreciate what you're saying, and with most issues, I think that you would have a winning argument there. I'm just not sure that you do when it comes to subject matter jurisdiction. Isn't subject matter jurisdiction one of the few issues that can be raised for the first time on appeal? Or maybe I'm turned around on this, but
I agree entirely. Okay. But it's not. I'm not arguing waiver. There's just no evidence. It's not. I mean, if there's a car accident in Volusia County and then somebody says, well, there may have been a subject matter jurisdiction issue on appeal. There's still no evidence. It's not a matter of it being waived. It was never framed by the pleadings, and
Right.
there's no evidence of it.
So
So
whose burden would it be to establish that the trial court does have subject matter jurisdiction?
the entirety of that would depend on the garnishee's answer. When KeyBank says my establishment of jurisdiction is KeyBank answering that we've frozen the money and that we are indebted. Remember, the garnishment statute says, are we indebted? Is there a debt due to the defendant? Here we have a depositor and its creditor. Mr. Longman is a creditor of the bank. The depository bank is a debtor of its depositor. And so they owe the money to Mr. Longman. It is a debt owed to Mr. Longman. KeyBank, unlike in Navy Federal versus Nicholas, KeyBank's not saying that there's any jurisdictional issue. They don't raise that in the answer. So I believe that this jurisdiction is established upon their answer. And that's what's distinguishable about all the lower court federal citations that have, by the way, I filed supplemental.
I don't know. I don't know that an answer remaining silent on subject matter jurisdiction establishes subject matter jurisdiction. Is there an opinion that analyzes that and says that? Why isn't it that you had to establish subject matter jurisdiction, and then if they wanted to dispute it, they would have to do something, right? Like, why didn't you have to establish it?
So under that theory, anytime a garnishment's issued, even if it's in a default posture, this is the problem with the case law. The federal case law is tainted because there's a pre-judgment writs of garnishment where it's completely different than post-judgment. In a pre-judgment writ, it's like the well has been poisoned in the district courts, and specifically in the Southern District, which, by the way, on August 5th, Judge Altanaga specifically said that power, rental, and all these cases are now bad law under Shim. This is the same district that said, and I filed supplemental jurisdiction. This came out 2 weeks ago. It said, because of Shim, those cases are no longer good law. They've been abrogated. And it is, again, it's on the record. I apologize for the late notice. It literally was, the opinion was issued August 5th, so I had no way of being aware of it. There's also Duval County Court case. I know certainly just persuasive and not binding on anybody, but where the court adopted the exact same argument that the trial court here did, and I believe they're persuasive. And in the case of the Navy Federal Credit Union case, so hypothetically, if I were to have to establish subject matter jurisdiction on any garnishment, what am I supposed to do? I issue the writ, the bank answers it, the debtor says nothing. And then the debtor's attorney comes on oral argument and says, there may have been an issue of subject matter jurisdiction. Oh, but what are you going to do? Are we going to be in a state of constant remanding back to lower courts anytime somebody just blurts out the word subject matter jurisdiction? I agree. It's not a waivable issue. There's just no evidence in the record of it. And if this court were to establish that line, if this court were to say, hey, the burden is on the creditor to establish subject matter jurisdiction, as difficult as an apparatus we already live in on collecting a judgment in Florida, what you're going to start imposing on creditors is the obligation to then affirmatively, I'm going to have to submit, we're going to have to go to trial, like a open chair trial, closed, no opposition trial, and present evidence of where the location of the bank account is?
Counsel, listen, I hear what you're saying, and I'm not saying you're wrong. I'm not saying you don't have a legitimate point here, but we're bound by the law, right? Doesn't the law say that an order entered without subject matter jurisdiction, which cannot be waived, is void?
But correct. That is a correct statement of law, but the analogy I would use is to maritime cases. And if there's something on the face of the record that shows there's no jurisdiction, but what other than attorney argument here, where is there any evidence of a lack of subject matter jurisdiction? There is none.
I guess it comes down to where's the burden? I mean, I think that is an important question.
But here we have the answer of the garnishee bank where they say that establishes jurisdiction. If KeyBank didn't, it happens all the time. It's happened in my office. Mr. Sullivan said it in his opening argument. What if a community bank in Ohio, if that community bank in Ohio has no branches in the state of Florida, then correct, there is no subject matter jurisdiction. Once you obtain in personam jurisdiction over KeyBank, which KeyBank has branches in Florida, which is why they answered the writ, then through Shim, you can establish jurisdiction to compel the turnover of those funds. That's the difference. And so, and there's case law that's just come out, including the First Circuit Court of Appeals. Just 2 months ago, I filed another supplemental authority on this. Again, these are all coming out because Shim, as you know, is a very recent opinion. Your Honor authored the 5th District opinion, and then the Supreme Court agreed with you. But that's only a 2022 opinion. So the case law is coming out fairly recently on this. I filed a second supplemental authority on this. The First Circuit Court of Appeals for the United States, it adopted exactly the argument that I'm making here, that the seldom, and even in Stancil 2, the Stancil case is cited by Mr. Sullivan, in Stancil 2, the second iteration of that case, it talks about that it's a seldom used rule. It's that the separate entity rule. A bank account, because of the modern banking practices of where money is essentially everywhere at once, that the seldom entity rule, which is what permeates all of these lower court opinions, that is no longer good law. A United States Court of Appeals has, and the citation was filed in the supplemental briefing we did, the supplemental authority, that the Court of Appeals has said that is no longer the case. That is what this line of thinking is predicated on. KeyBank, because we have jurisdiction over KeyBank, number one, because the KeyBank answered the writ. Number two is, and Mr. Sullivan said, oh, it's a Venetian salami. What is required under Venetian salami? It requires under Venetian salami that you file an affidavit challenging jurisdiction, which would then impose on me a.
So is it your position that maybe I was misunderstanding what you were saying before? Is it your position that the answer actually admitted, in essence, that the account is in Florida? Is that
Right. That
Okay.
is exactly right.
So it's not, you're not arguing that there's a complete lack of information on the point at all. You're saying the answer essentially admitted the location of the account.
Correct. Because the garnishee, like many other garnishees, have utilized their ability to say I forget the name, a couple of the cases that are cited in the initial brief and in the reply brief, they discuss a different apparatus. They're talking about garnishees who are contesting these contemporaneously. There's a 2025 case that predates from the Southern District that Mr. Sullivan cites in his reply brief, and it talks about J.P. Morgan. And J.P. Morgan contested the garnishment, and they contested the jurisdiction. That is not, and so of course in that case, the way the pleadings are framed, the writ of garnishment and then the answer of the garnishee, I would agree with that. But if a garnishee says, yes, the funds are being held in this amount, I believe that answer establishes that there's a admission of subject matter jurisdiction. Could Mr. Sullivan file something directed towards that answer, contesting it, and present evidence? Of course, I'm not saying that that's not. There could be evidence presented. But we had an evidentiary hearing on that, and that never occurred. So that wasn't done. KeyBank's answer.
Tell me the best case or two, federal or state, in your opinion, that discusses this sort of burden to establish where the account is, or this sort of concept that the answer saying, hey, yeah, we have the property, without directly addressing location of the property, that establishes it's like sort of an admission, I guess, if you will, or it establishes the location. So either one of those, what are the one or two best cases that you think addresses this?
I don't have a specific case on that exact proposition, because customarily when the bank answers that the funds are subject, there's other defenses that are raised, like tenants by the entirety or whatever it may be. But that issue usually is not at play. And so there's not a case that really directs it, because it's an unusual. The reason it's unusual is because normally when somebody's going to contest jurisdiction, it occurs at the pleading stage of the garnishment. It's going to be the garnishee and the answer contesting it, or the debtor. And so, here, the fact that it occurs,
just like Vanguard did in this case.
That's exactly right, Judge Bo. Exactly the way Vanguard did it is, and that's why I was glad Mr. Sullivan raised it in his initial brief. That is exactly the way that if a garnishee, that's why, by the way, my client Vanguard settled.
So are you saying that you don't even think that, are you not even applying the Shim case to this situation?
In this particular hypothetical, it really does. It's outside of Shim's scope. It's that in Vanguard's situation, Vanguard filed an affidavit saying, we don't maintain a home office there, which is, by the way, news to me. Vanguard's a massive company. I figured they had more of a footprint in Florida. But Vanguard established through its affidavit that that the court does not have jurisdiction over us. And Vanguard, in their answer, it's very important. Vanguard, in its answer to the writ of garnishment, specifically stated that these funds are held in Pennsylvania, and because of the nature of the account, it's a brokerage account, it's not subject to Florida's jurisdiction. So Vanguard, that's a perfect example of the pleadings being framed such that there's proof. It would then, my burden would be to rebut that.
Did
Because
Vanguard appear at the hearing? They appeared at the hearing and contested.
Vanguard appeared at this hearing. The
KeyBank
hearing is
did not? Did KeyBank?
KeyBank never appeared at the hearing. KeyBank always consented to the jurisdiction of them with the court over them. And so I appreciate you bringing up that example, because I think it is illustrative, Judge Icicle, of exactly the way that would be supporting Mr. Sullivan's position. If KeyBank had answered it in the way that Vanguard did, but notice in Vanguard, what did I do? I ended up dissolving the writ of garnishment, working it out with Vanguard directly. But in KeyBank, that's not an issue. So, and I'd also urge the court, the three, again, and I apologize for the belated filing on it, but the three supplemental filings that were done, the August 5th opinion and I'll give you the citation. It's the Busking versus Aloshi Bros, BROS, and that was in our supplemental filing, August 5th, 2025. It's at U.S. District Lexus 150189, where it says, it's citing the power rental and the schoolless case, okay, which are both cases that support the argument that Mr. Sullivan's raising. It says, those cases have been abrogated by the Florida Supreme Court in Shim. That's directly from that opinion. And then the county court, again, it's just a county court, Duval County, but it's potentially persuasive. And it says, very recently, the Florida Supreme Court held its well-established personal jurisdiction over a defendant, gives the court the power to require the defendant to refrain from doing anything beyond the limits of its territorial jurisdiction. And it cites to Shim versus Buchel, quoting Fall versus Easton, which Your Honor, Judge Icicle, you also cited to in your Buchel versus Shim. And it said this is also supported in the context of garnishment by Stansel versus Revolutionary Armed Forces of Colombia. So this opinion, which was authored after Shim, discusses that it's also applicable in the context of garnishment. Again, I'm not saying that's binding. Of course, that's not binding on this court, but it should be looked at as persuasive authority. And then the second supplemental filing that was again a very recent case is the power rental OpCo LLC versus VI Water Power Authority. That's at 142 Fed 4th 17. And that's a First Circuit 2025 opinion that just came out. And it's also discussing all of this. It doesn't discuss Shim specifically, but it says, hey, the separate entity rule is arcane. There's really no support for it. In fact, there's references in these Florida opinions cited by Mr. Sullivan where the separate entity rule is seldom used, meaning that every branch of a bank is entirely unique and separate. That is, there's now opinions coming out, including the one that I'm referencing right now out of the First Circuit Court of Appeals, which I just cited to, that say that that's no longer applicable. And certainly it is, and look, I'm a textualist. It is strict construction of the statute, just like Your Honor. I mean, Judge Icicle, in Buchel, you stated, and you raised this with Mr. Sullivan, extraterritorial, there is no reference to extraterritorial effect in the preceding supplementary statute. I think it's very important to address that. There is, but it says any assets of the debtor. The same language, the same broad language appears in the garnishment statute. Any property of the debtor, tangible or intangible property. If there's not a restriction, we have to strictly construe the word any. Any means exactly what we all can infer that it means. And so
Counsel,
that means.
So how is this case different, if at all? If, let's say for a moment, that our record establishes that there was not subject matter jurisdiction over the account, but somehow it all got missed. The garnishee did exactly what it did, didn't raise it, all that stuff. Everything else happened exactly the same, but somehow our record established without a doubt that the account, that the trial court had no subject matter jurisdiction over the account. How would that change, if it would change this case?
You would still have jurisdiction over the account, because under Shim, there's no reason that Shim's holding cannot apply to garnishments. It's because you referenced the Navy case is a very short opinion. It's very, and I understand there's propositions that directly apply here, but again, it's framed with a garnishee. It's framed with an answer to a garnishment that specifically contests jurisdiction. Like Judge Boatwright said, that's what Vanguard did. The Navy case that just came out of this district is identical to what Vanguard did. But you have to juxtapose it with what we're dealing here with KeyBank, which is entirely different. So while of course it would be binding on this court, Judge Wallace authored the opinion. That opinion is narrowly tailored to a separate species of garnishment answer where there's
But
actual.
your point is that if the record demonstrated that the account was out of state and that the trial court didn't have subject matter jurisdiction over the account, then you would say, hey, you still win, but for a different reason. Then you would say shim applies.
Correct. I would say shim applies. Exactly. There's two independent reasons. And the reason shim applies, Your Honor, don't be mistaken. I'm not saying that you can, that small Ohio credit union that Mr. Sullivan referenced, I don't believe this court, that's beyond the long arm statute or any constitutional ability. We cannot go, a bank that has no branches in Florida that we don't have personal jurisdiction over, we cannot compel that bank to do anything.
Well, unless they waive personal jurisdiction, right?
If they waived it, but that's not what occurred here. We have a garnishee who we have documented personal jurisdiction. It's completely it's uncontested that we have personal jurisdiction over that garnishment, over that garnishee. Therefore, shim directly applies. And shim was a very thought out, lengthy opinion that dealt with Florida Supreme Court scrutiny, and I think that needs to be considered in this context. And so.
Is there a difference between a garnishee, though, and a defendant? The defendant actually owns the property. The garnishee doesn't. Why isn't that a difference in the quasi in rem nature of this?
There's no difference because the garnishee is a party to the case under the statute. So it's a semantical argument that Mr. Sullivan, he conceded. There's no case law to support that. You asked that during Mr. Sullivan's arguments, and there's no case that supports it, and he acknowledged that. The garnishee and the defendant. The fact that proceeding supplementary deals with the defendant and garnishment deals with the defendant and a garnishee. Here, the garnishee answered the writ of garnishment. There's no distinction and never contested jurisdiction. There's no distinction that.
But when it's not, and Counsel Sullivan, I'll give you a little bit extra time, but when it's not owned by the garnishee, the property's not owned, isn't it more like when the court is saying, I have personal jurisdiction over the defendant, you go get your property and bring it here. Isn't that different than when the court says, hey, entity who doesn't own the property, but you happen to have it in your possession, bring it here? Isn't the latter a little bit more like the trial court seizing the property?
But remember, this is all premised on the trial court having jurisdiction over that garnishee in the first place.
No, and the trial court has personal jurisdiction over both. But when the trial court says, hey, garnishee, I know you don't own that, but bring it to me, I want it. Correct. Isn't that a little bit more like seizing it? And wouldn't that be a little bit more like quasi in rem?
Well, it's compelling the garnishee to pay the money to the creditor. I think shim fits absolutely perfectly in the garnishment context. And let's not forget, this is in the backdrop of a judgment debtor who's been moving millions of dollars around the country. I mean, and again, I hate to make a policy argument. I am a textualist at heart. But here we have a Florida statute that was used in shim because that money that was sitting in the Korean safe deposit box, you compelled the judgment debtor, and the Supreme Court agreed with you, Your Honor, that money needs to be returned. There's no difference here, especially here where the garnishee's not even fighting it. There you have a defendant who's fighting it, saying, I'm not going to do it, is being obstructive. The garnishee here is not fighting it. And so in the context of Vanguard, exactly what Judge Boatwright said, with what Vanguard did, I would agree wholeheartedly that, okay, now you're trying to force Vanguard to take funds in Pennsylvania and to pay them to you. I can't do that. But that was because that was raised by
counsel. Go ahead and wrap it up so we can.
Your Honor, just very briefly to address the tenants by the entirety issue, the strict construction.
Counsel, you're out of time. You got like 30 seconds.
Your Honor, the trial court's order and it is should be affirmed. It's well thought out. It's consistent with Your Honor's holding in shim and the Florida Supreme Court's adoption of that. And I'd also ask the court to review the supplemental filings, and I apologize for filing belatedly, but again, they just came out. I think those will also help to illustrate the point. But the trial court's order should be affirmed. The Navy credit union case is inopposite for the reasons we discussed, and I appreciate the court's time.
Thank you, counsel. All right, counsel for appellant, we'll give you 2.5 extra minutes if it's needed. Go, you're recognized.
Thank you, Your Honor. To answer a question that I feel like might have been left unanswered, I would direct the court to Judge Corrigan's well-researched and well-thought-out opinion in Power Rental. It's not reported in a Fed Sup, but it's 2021, Westlaw 988-1137. It's also cited in, I believe, I know it's cited in our initial brief and our reply brief, and I believe Story Mountain cites it in their answer brief as well. If you read through Judge Corrigan's opinion, he takes a survey, and July 6th of 2021 is when he authored that opinion. But he takes a complete survey of what the status of the case law is, both out of the state of Florida and the federal courts in applying the garnishment statutes to try to determine where is the situs. Right? Because in the e-commerce world, you deposit money into a bank and it removes itself from a physical form to a digital form, accessible anywhere that bank has locations. So does that mean, and the question I think that's being asked of this court is, if you turn it into that digital form and it becomes accessible anywhere that bank has a branch, does that mean it's located everywhere and nowhere at the same time? That's really the question. Right? Because if that's the case, it's going to dissuade individuals who may not want to be subject to a garnishment in the state of New York, but they have a Bank of America account and they'd still be subject to that garnishment. Right? So that's what we're looking at here. And the difference between what the argument of, hey, listen, because Key Bank didn't say, hey, listen, you don't have jurisdiction in the answer, that's hamstringing any garnish or judgment debtor in this case, from raising their own rights, right? Whether or not Key Bank is subject to the personal jurisdiction, that's for Key Bank to figure out. No judgment debtor could ever raise that right. I think that's well elucidated in the Merriam-Webster case cited by Story Mountain. You can't raise rights of third parties. So to take the opinion of a judgment debtor can't raise quasi and rem jurisdiction, or in this case, subject matter jurisdiction over the actual thing to be acted upon because it wasn't raised in a garnishee's answer, I think that is the taking away of rights, right? Again, I'll go back to what I argued earlier. It's not like Key Bank owns this money. It's holding it as a third party for Mr. and Mrs. Longman. So I'll go ahead and leave that at that unless the court has any other comments.
Mr. Sullivan, if we take your argument to its full conclusion and you were citing the body of cases that Judge Corrigan included in his analysis, is the only means by which the quasi-interim jurisdiction would be established would be if the money was literally deposited at a key bank branch that was located within the jurisdiction? That would be the only way that the court would have this quasi-interim jurisdiction?
Correct, Your Honor. I think that's the logical conclusion, because if I take my paycheck from my job and I go down to my corner bank, Bank of America, and I deposit it in the account, I physically had my check in the state of Florida. I deposited in my local branch here in the state of Florida. Just that transition from a paper check to a digital form, that can't transfer the location of the situs. This would be a unique and novel idea that is not applicable anywhere else other than an electronic financial world, right? So if I get paid, let's say I get paid in cash, that doesn't mean the car accident in Georgia that I got into 3 weeks ago, that my cash for my pay can be subject to that. So
I think that what you're saying from that then is, aren't we talking about basically it's turning into financial battleship? I mean, you were going to could encourage your client, okay, deposit your money in a certain location and just make sure that whatever breach of contract or whatever cause of action that you commit, it's not done at the same location where the money is located. You can do that elsewhere, but just make sure that you don't have your cause of action accruing in the same jurisdiction where you deposited your money. I don't know that that was the intent, or that should be the intent. It seems like it's very elusive, very ambiguous, and can ultimately result in a party never being responsible or having their property located within the jurisdiction of where you're trying to bring a cause of action. Don't you see that kind of the maybe almost weird result here that was going to result in a very elusive ability to hold property in a location, correct?
Well, Your Honor, I understand where you're going in the point with that. However, I would challenge that logic based on the domestication statutes, for example, that the state of Florida has. Story Mountain's entirely free to go visit Mr. Longman and Mrs. Longman's home state of Connecticut, domesticate the judgment up there. certainly a Connecticut court would have jurisdiction over not only their money that Story Mountain seems to believe is located in the state of Florida, but they'd have jurisdiction over houses, cars, boats, any other physical, tangible asset that you can put your hand on. So while I appreciate your honor's thoughtfulness, I think the domestication statute that I believe so many other states have, I think it takes care of that, right? So if they can go to the defendant's home state, domesticate their judgment,
Well, and they
proceed-
could also go under 56, right?
Correct.
But I mean, I think another of Judge Wallace's points is interesting, though. I mean, look, at the end of the day, can't you go to any Keystone branch and withdraw the money? Why isn't that account everywhere?
Your Honor, that would be the only time in the history that I've been able to find as it pertains to garnishments that we have said money turned into a digital form becomes everywhere and nowhere at the same time because you deposited it in a financial
Well,
institution.
maybe not nowhere, maybe just everywhere, right? I mean,
Maybe
because
it's everywhere.
he literally could show up anywhere that there's a branch and say, hand over my money, and they would do it.
Correct. But if we extend that logic, Your Honor, I could take, let's say Savannah's got a local community credit union and they give me a debit card. If I pay for dinner down here in Florida in Daytona Beach, does that mean now that money is located in the state of Florida because I have my debit card here in the state of Florida and I'm paying for dinner here?
I think that's
No.
different than having
It-
a
it-
branch.
I agree with Your Honor. It is definitely an extreme example, but I can.
You're not contesting that Key Bank doesn't have a branch here. You're just contesting that the funds are located in Ohio, correct?
Correct, Your Honor. That is the key distinction here. And naturally, we can't raise their personal jurisdiction argument. The crux of Mr. Longman's argument here is that there's no in rem jurisdiction. And to briefly wrap up, because I believe I'm at the end of my time, I think the brief fairly well points out the distinctions between 7707 and 77041. That's a plain reading of the statute, which I believe this court's case law suggests that it's required to give the plain meaning of the words. And if the court, or excuse me, the legislature says one thing, it means to the exclusion of other, especially when they show in similar statutes that they know how to differentiate and identify different things they intend. So for the reasons argued, we'd ask that we reverse remand with instructions. Thank you.
Counsel, very interesting case, very well argued on both sides. Thank you for your efforts. And with that, we will be in recess. Thank you.
Thank you.
Thank you, Your Honors.